Okay, I'm recording now. So thanks everyone who is joining this panel, this study group. We have I'm the moderator. My name is Paolo. I'm a member of LexDAO. So LexDAO is very happy to. This is basically the last series about MiCA. We had other sessions about MiCA. Some of the panelists here already participated, and Marina and Yara for sure in the other series. And this is probably, in my opinion, at the very least, the most important topic in MiCA about decentralization. So I will introduce briefly the panelists. We have Marina, who is a UCI founder. It's basically a group, an entity created doing lobbying and education in crypto. We have Yara, who is also from UCI. And we have Elvin Sababi, who is a lawyer from Sweden, and Mats Ribe, right? Sorry for the pronunciation, is a lawyer from Norway. And so we will speak about decentralization. Decentralization is very important because, as we all know, the entire crypto space is built around the idea of decentralization. Now, MiCA, this regulation of, and just will make a very short intro, is built around the idea of decentralization. And as I was saying just at the beginning, before that we started, in my very personal opinion, decentralization is not only a question related to tech, but it's also probably a social value which is important for crypto. It's really a cultural value shared among the crypto community, because and for example, some banks that under the DLT regulation Europe are creating projects with blockchain have nothing to do with decentralization, probably are just outside crypto. But that is only my very personal opinion, maybe a little bit extreme. So in MiCA, we have a Recital 22, which expressly address the decentralization, which is very important because as far as I know, is the first piece of law around the world which explicitly states about decentralization. So I will give now the floor to Yara, and I will ask you, Yara, if you could give us a brief explanation of decentralization in crypto. Thank you.
Yes, thank you, Paolo, and thank you all for having this, for organizing this. So I would make it very brief, actually, as brief as a lawyer can make something brief, because even from our preliminary discussion, I believe that it would be more interesting for us to actually have this more of a back and forth approach, because it really seems that we all have varying ways of understanding decentralization, which was very obvious when we were also discussing the topic before starting this. So I would say I will go with a structure that makes sense for me, and then we'll just leave it to also be picked apart by you. Also, Paolo, I would be super curious to hear your thoughts, more of your thoughts. But for me, decentralization, and I'm talking as a lawyer, is basically what makes the crypto industry so complicated from a purely regulatory and legal point of view. Because how law works is we need a centralized entity, we need a specific person that would at the very least register a postal address where different messages can be delivered and where different information can be sent and where that person or entity can be found if anything goes badly. We do not have this when we talk about decentralization, at least purely decentralized projects don't have that. And that's going to be a separate discussion, I believe, when the other panelists start discussing Recital 22, what is fully decentralized, what is not fully decentralized. But when it comes to decentralization in a broader sense, what we have is this lack of centralized entity that controls and makes all the decisions, which from a legal perspective is pure hell. So that's how we can also interpret what the EU in particular is doing when it comes to decentralization. What forms of hell are we trying to contravene at this specific point? So it all started. I'm not going to go into the historical details that much, not going to offend you by doing that. But still, when we started with Bitcoin, it was a completely different situation. So back then, it wasn't as adopted. It wasn't crypto wasn't as widely used. So the regulators, from like the purely regulatory perspective, weren't so inclined to intervene. But then with the development, we also had different ways of understanding what this community is about, what this technology is about. Also, other issues started emerging. So in a sense, if it wasn't for what we broadly call the DeFi summer, we would not have had a big chunk of the legal issues that we currently have. And again, when we talk about decentralization, we should not only talk about DeFi. So decentralized finance is not the same as decentralization. This is something that even I sometimes forget. So you can only imagine how complicated it is for regulators to understand. So we are having this discussion that is far broader than, yes, it's the underlying technology, but then you have the whole complexity of what is happening, how is it happening, how is it affecting people at this precise time, and then how that triggers the regulatory reaction, and then triggers also our response, jumping from different perspectives. Academia analyzing, lobbyists lobbying, lawyers helping clients also understand what is happening. So in a sense, I will just also kind of, by also introducing Marina's part, provide this kind of a short summary of currently, when it comes to Europe, what is happening in like decentralization and regulation. We obviously have the Markets in Crypto Assets Regulation, MiCA, where decentralization is already mentioned in Recital 22. What that means, totally different topic, but we have other frameworks that are also touching upon that quite a lot. So we will also always have this conflict between decentralization and the lack of one specific person and entity and anti-money laundering provisions. So that's something that either through the Financial Action Task Force, transfer funds regulation, but it will always be there. No matter even how we might perceive decentralization from a purely conceptual point of view, as long as there are some issues related to those topics, none of this would matter. So that's one thing. And also the identification, which is a broader topic that also touches upon privacy and so forth. So those are the things that I wanted to highlight. I would be extremely curious to hear your thoughts also, and to have some sort of a debate and discussion. But yeah, that's in a nutshell where the issues are.
Okay, thank you, Ivea. I would say let's finish to hear from each panelist, and then we can start the discussion maybe. So next one is Marina. I already introduced her, Marina from UCI. So the question for you, can you please explain to us the behind the curtains political negotiation related to decentralization in MiCA? Why the European Union decided to write Recital 22, basically?
Yeah, thank you for the question. I hope you can hear me well. So I will also try to make it brief, and I think this is an amazing opportunity also from seeing who joined this call to have a discussion later. But just briefly,
ciao Tommaso, sorry, ciao Tommaso.
From the ones that might
ciao,
not
everyone.
know.
Ciao, everyone. Great to be here. I'm just moving through Brussels, so I hope I'll be able to participate in the discussion, but very happy to be here, at least to listen.
Hi, hello, hi everyone. So yeah, the interesting part of this was that, as you all know, MiCA was really a reaction to Libra and to the stablecoin parts. And those were really important because they also were somehow threatening the financial stability of the European Union. That was the reasoning why we had this first regulation in place. And of course, during that time, it was pretty early, as everyone can imagine, 2018, 2019, etc., 2020. At that time, DeFi was not a big thing, at least not at the beginning, but then the DeFi summer came. And this is where also as EUCI, we started introducing this notion to specifically the Commission that there are different things. They're not only decentralized exchanges that you want to regulate, like crypto as a service providers, but there are also different type of like decentralized applications that we know exist, that we know there's a market cap for. And I remember during that time, the market cap was growing and growing. We had these presentations, and every time we had one, we had to update our part on the market cap because it was changing every week. And basically, what at the beginning was important is just to make and basically educate that there are two different types of applications or in any way groups, how they're formed, one centralized and one decentralized. And during that time, there was so many questions. There were so many questions that we had to answer regarding MiCA and regarding the centralized entities that we thought the best thing would be to postpone or to leave out the decentralized use cases because we were not at all ready yet to understand how to regulate, if regulation is needed, and in which way this should be done. So this is where the idea of the Recital 22 that is now in place came up and saying, this is something that does exist. DeFi is out there, decentralization, decentralized applications are out there. We still don't know how much they will grow, what will happen from 2020 on, and how important they will be, and how, what specifically are the risks that we need to address within regulation. Let's leave it out for now. And luckily, that was also accepted. I know that there's like a lot of discussions right now if the Recital 22 is really the best one we can have. Could we do it in a different way, etc.? But I think that as things were happening during that time, that was the best that we could do. And we also wrote a whole basically report on our papers and our responses during that time. I remember it was the end of 2021 and beginning of 2022, and specifically one paper that we sent to regulators asking for that. And again, luckily that was a part of it. And now we have it. Now, what is important is for us to understand, of course, how to apply it to all the existing, in a way, national competent authorities, how they will interpret this part. And there's like 1,000 of questions. I know that we will go more into this with Elvin and Matt later on. And there's a lot of discussions that I know Paolo will open. For example, is decentralization something that could be seen as tech neutral? I have a few other questions as well. Can DAOs be built on top of non-decentralized blockchains or not enough decentralized blockchains? We know there are different blockchains out there today, and some argue that some are less or more decentralized in a way that some can be stopped for some time, etc. There are other questions. Can decentralization be jurisdiction specific, or should it be jurisdiction specific? Or it will just be something that we all know as other legal terms are. It will be a specific definition in the EU, and then we'll have another definition in the US or Canada or Asia. That is, of course, something that I think in theory we really don't want. And another question is also very interesting is how far can we go? Like how high the bar of decentralization is, and how high this bar is looked at from the authorities' perspective, and how much can we even achieve realistically, operationally as DAOs in the space. So those are a few questions. I think going forward will be easy, interesting to discuss. But yeah, that was just a short intro from my side.
Thanks. So Marina, thank you very much. You already put a lot of stuff on the table. I would say a lot of interesting questions. I would proceed with the other panelists, then we can start a debate maybe. So next one is Matt. So my question for you, your opinion, can you tell us if, and from a lawyer perspective, I'm a lawyer as well, Alvin is a lawyer as well, so we are clients. And so is decentralization Recital 22 an exemption? Can we say that there is a decentralization exemption, which means for non-lawyers that basically, because the main problem is, of course, that there is a burden for projects that, for example, wants to that are CASP and they need to get an authorization. So is an exemption from a legal point of view decentralization? And if yes, which is the impact? Thank you.
Thank you, Paul. I hope you can hear me okay. I'm currently in a hotel lobby in Thailand, transitioning from my current employer at EY to
Matt, can you?
Outlook.
We can hear you very well.
You can't hear me okay?
Yeah, a little bit better. Thank you.
It's a little better now.
Yeah, now yes.
Yeah. Okay. Let me know if the problem continues, and I'll shift my headphones. But no, this is a really big topic, and I think you're going to see lots of different interpretations from NCAs and also some of the courts in EU and the EEA area. Going back to the WASP regime. You had some of the same questions there in terms of what is considered an exchange, right? I want to give an example because we represented an interface back in the days, and
Matt, sorry, it's going.
And it was a big
Matt,
question, whether or not.
Matt, sorry, the voice going down. So if you, I'm sorry.
The voice is going down. Okay, then I'll try to.
I don't know if that was my impression only, but yeah, it was not only my impression.
Is it a big better now?
Much better.
Yeah.
Much better.
Okay, but let me know if there's lots of background noise. Then I have some other headphones I can try afterwards. But okay, I just wanted to go back to the WASP regime, because under the WASP regime, right, you had some of the, let's say, same interesting questions of what is considered an exchange. Especially in relation to interfaces, right? Just connecting or routing their customers to a DEX or decentralized exchange. When the WASP regime was implemented from the EU's, fifth AML directive, at least in Norway in 2019, you just had the text. But since 2019, you see that the Norwegian NCA has really tightened or actually widened the language in terms of how it's being interpreted. So they wanted, after a few years, they wanted to increase the scope of who needs to be registered under the WASP regime. And that led to uncertainty, definitely, with banks. So even though the AML fifth directive was quite did not change, you had the interpretation of it from the NCAs changed, right? They widened the scope, and the scope was widened to who is facilitating an exchange needs to be registered, which is something different than the wording, at least from my opinion. And that led to interfaces not being able to hold a bank account, because the banks basically concluded that the interfaces needed to register with the NCAs, even though the NCA didn't have any particular decision on it. And even though we provide a legal opinion that that we argued that the company being just an interface, routing customers to an underlying DEX, or even to just be an agent to another company who is then routing customers to a DEX. Even those need to be registered under the current WASP regime. And I think that's what really widens the scope, right, of who needs to be registered. And I think that we're going to see the same under CASP regime, that at least some NCAs, quite strict NCAs, just like the Norwegian NCA, they will seek to widen the scope of who is considered a CASP, and basically say that the exemption under Recital 22 for fully decentralized will be really, really narrow. And that's why I hope at least that you will see some bold companies challenging the NCAs, at least the stricter ones, and going to court to have some real decisions, not only on, let's say, the interpretation from the NCAs, but on the basis on the language of the act, right? Because otherwise you will basically say that Recital 22 and what is considered fully decentralized doesn't really hold any independent meaning unless you are really, really certain and you have the really, really narrow exemption. Obviously, I think also the crypto market has, they don't do themselves a favor, right? Because they don't only want to be the software provider, they also want to, you know, actually facilitate the exchange, right? So if you look at the TradFi sector, you see, for instance, IBM or, you know, similar companies providing tech to the banks. They don't have to be registered as a bank, right? Obviously, but they also merely being a tech provider. Now, under the crypto industry, the software providers, just like an interface, in many occasions don't only provide an interface routing possibility or service. Sometimes they also develop the DEX themselves. So they also, you know, offer the DEX on the market. It's out there. Anyone can develop their own interface, but they offer the first interface, the most common used interface. And suddenly, and they also provide maintenance for the DEX, right? And obviously they can argue that, you know, this is still open source. Anyone can provide interfaces. Anyone can, you know, use the code in order to fork it and provide a different version. But if you both develop the DEX, you have the interface, you are maintaining, you know, the full technology, conducting the exchange, then obviously you're not only being kind of the tech provider because you are actually wanting to take part in the exchange, right? And so that's why you see some of the crypto providers, they tend to step a bit further than just being a tech provider, which then leads to the uncertainty. But I definitely hope that you will have some bold companies challenging some of the stricter NCAs so that we will have some more clarity, some more examples going forward.
Well, thank you very much for this. So now we have our last panelist, and then we can start a debate. So Elvin, so the question for you, if Recital 22 is an exemption, in your opinion, is it possible potentially to discuss with the local, with the National Financial Authority, NCA, as they are defined usually, such exemption for a client and get a no action letter? A no action letter is something, just explained for non-lawyers here, is when you want to be sure that what your client is doing is not infringing any law. So just to be sure, you're asking an official opinion from the financial authority and say, okay, we think this is not infringing any law. Can you, are you of the same opinion? Just please put us in writing so we can move on with that. Is it possible for you, Elvin? What do you think? Because it should, in principle. Thank you.
Thank you, Paolo, and thank you for arranging this panel. A great topic, and thank you for the question as well. The short answer is no, unfortunately, at least in my experience. We tried this in Sweden. We even had a client who was contemplating to apply for a license and hope they would be denied. But I highly doubt that the NCA in question would motivate it, because they were fully decentralized and hence outside of the scope, which then would defeat the purpose, because this was a DeFi platform where they hosted interface for a DEX. And this is my experience, at least from the Nordic countries. Maybe there are other NCAs across Europe that have gotten, that are further in their knowledge, I would say, when it comes to DeFi, because if we take it back, why I believe the answer is no, I believe there's a huge knowledge gap here between NCAs and understanding not only the crypto space, but then moving further, understanding the concept of decentralization. I don't think that it helps that the industry itself, the crypto industry, is somewhat scattered on the topic. Like this is a common debate on Twitter still. So I don't think there's a golden standard yet that we all agree is considered at least fully decentralized. Although we, you know, scholars, lawyers, ecosystem and participants keep writing about these topics. I still don't believe that there is a fixed golden standard, and considering that there's then adding on top of that regulators are not accustomed to regulating or taking into account decentralized structures. As Vera said, they're used to having a centralized party and intermediary, which they then can force rules and enforce against. So I think, and this has not been confirmed, but I think many NCAs will, for the time being, maybe take a step back and wait and see how this plays out, and even maybe wait for further clarity from ESMA and EBA before actually starting to pursue and digging into this topic. And then also, I mean, I guess we will touch upon this, but then what happens and if different NCAs do different interpretations, etc., etc. So it's a big topic and quite a challenging one, I would say.
So thank you very much. And before opening the debate, I just want to add two things. First of all, that there is, and I think no one mentioned here, that I think is worth mentioning, there is an opinion or a guideline maybe from the Danish Financial Authority about decentralization, which in my opinion, this is just only my very personal opinion, doesn't really say too much. I mean, says a lot of things, but or maybe was difficult, but doesn't solve. But at the very least, we should, I think, praise for the Danish authority that to open this to write something about decentralization, because, and I would say that the Italian NCA will never grant an exemption for decentralization. They will get really kind of offended if you try to do something like this. I didn't try, but this is just on my feeling. I wanted to add a personal experience, which is not about MiCA, but is about decentralization, and I think is an interesting one. I had a client more or less a couple of years ago, which was a cybersecurity case, and maybe was a cybersecurity case, and my client was a totally decentralized project. They issued a token, but was totally decentralized. The smart contract was renounced. There was no legal entity, no legal wrap. It was totally decentralized. There was a strict decentralized ideology, and they said, we want to stay decentralized. We even renounced the smart contract. Okay. Basically, they what happened, and I cannot give the details, but just the idea, because it's still everything confidential. Basically, what happened is that they had locked the token into a facility, and the facility, I call a facility because I cannot give more details. The facility was hacked, and they lost the entire project lost a lot of money into this incident. So what happens is that the responsibility of this facility was very clear, because the smart contract of the facility had been audited 1 month before, and the audit said that it was totally weak. And so what happened, I started an out-of-court negotiation with the counterparty, and so the negotiation was not about the responsibility, because that was clear. So the answer of the lawyer of the counterparty, which was a big law firm in Northern America, I can't say more than that, was not about the responsibility, because I repeat, that was clear. Interestingly, this company holding this facility was just working in the crypto space. So probably most of their clients were decentralized or semi-decentralized. So the entire defense of the counterparty was, who gave you the mandate? Since it's a decentralized project, who gave you the mandate? Do you have a mandate? Who signed the mandate? And also, if we pay your clients, how do we know that we are really paying those who have right to get compensated? And we have been exchanging a lot of emails about this point back and forth. I was even with my clients trying to find some creative solution about signing a transaction from the token holders. I mean, at the end, everything ended with a negotiation. We made a deal basically. But I think this was interesting because there are even practical problems. Because, for example, if and Elvin was answering to my question, but maybe a nasty NCA could answer who gave you the mandate. If it's decentralized, in principle, no one should be able to sign on behalf of a decentralized organization. I can also add, because some couple of years ago, I wrote an opinion about privacy, GDPR in Europe, and for a decentralized project. And I think everyone here will be familiar with the concept of controller in GDPR. GDPR is based under the idea of controller, meaning that there is one subject who decided to start the processing of data. So under the GDPR, this European Union regulation about privacy is basically responsible for everything. So you start to process personal data. It's your responsibility to put in place the compliance system mandated by the GDPR. That's more or less the idea. So I had to write a legal opinion about the point if a decentralized project can be or cannot be a controller. And I found an interesting case law from the ECJ, which is the European Court of Justice, about a religious group, which was neither an association, was just decentralized, if we may use this word. And under this case law, under this case of the European Court of Justice, that could be considered to be a controller. So I use that precedent as to say that, of course, it's different, but still similar. So even probably a decentralized organization can be a controller using this precedent of the ECJ. Just wanted to say this. So please, if there are questions or from the panelists or from the public, please. Rina, maybe you had a lot of questions.
Maybe I will go next. I think this is really interesting and super valuable to understand what's happening within all the national competent authorities. We know that there's a lot of them. As you mentioned before, like 27 plus 3 with the European Economic Area. So 27 different opinions on what decentralization is. And I think that from the negotiations, I can say realistically that even the authorities and institutions in Brussels, when this was negotiated and discussed, etc., they had a very conservative thought about what decentralization is. I think if we wouldn't have Bitcoin out there as something that people knew about what it is and that it does exist, and maybe then Ethereum, like it would be really hard to negotiate this part within MiCA as well. And we have like a pretty high standard. So like, do you need to die as a founder to be decentralized in order to be decentralized, or can we have some other solutions? And can we show that it is possible to be exempt from MiCA as it was discussed before? I think that within the opinion from the Danish paper, within what you just discussed, in theory, it is really hard to be decentralized. I think specifically the front ends that you mentioned, it's a completely different question here. Front ends, applications, website, etc. How do we access a specific, in a way, application? I know that with some people in this call, again, I discussed this multiple times, but we do have, of course, arguments as lawyers, as advocates to say that, of course, anyone can enter this application. It doesn't need to be that website and this front end. So it is accessible to a smart contract directly. The front ends could be multiple, etc. We all know those arguments, but in a way, it is just limited to the time you have within NCA and to using the best arguments for them to really assess this decentralization idea. When I'm thinking about this in very general, like assessing where we are at this point in time, knowing all the different position papers and ideas that different national competent authorities and I would say institutions have, we do have quite a lot of, I would say, indirect information in which direction those things can go. As you mentioned, we do have the DeFi paper from the Danish authority. Now we have a very interesting assessment on how auditing should be done on smart contracts, for example, from the French authorities. It's not directly linked to, I would say, decentralization, but in a way, if we think about specifically under the Danish paper, how a decentralized application should look like, it definitely includes smart contracts. So if then the smart contract need to be compliant or certified in a certain way, again, who does the certification, how the whole thing works, and then how, in a way, can we assess that there is a safety behind this decentralized project that is out there. Another thing that we had in the past as well was this papers from IMF and ACPR, again, the French authorities, as you all know. I remember in those papers, they were even questioning how do we assess, again, the security of a blockchain on top of which all these potential DAOs are built. Again, can we assess that? How, like, who will do this assessment? So looking into the whole, you know, all the layers of the application, can realistically an NCA have the time and all the knowledge to understand all the layers, again, before they come to this application, before they only see the website or the application or the front end, looking into everything that is behind it. And also, there doesn't need to be one entity. There could be multiple entities, a universe of entities, and all those represent a DAO. They might have different rights, obligations, etc. We know different theories here around repped and unrepped DAOs, etc. And then the last time, and then I will stop here. But the last part is really the activities. So we're talking here about DeFi, but that there could be different activities that a DAO can do that is not as regulated as, for example, financial activities. Can we leave those DAOs to be, you know, in a way decentralized, although they would not even come into the MiCA scope or discuss this part as well? And the last thing I want to say that there is some activities around the European Commission. I think there will be something written like a report or research on DAOs. That would be very interesting to see what it has to say. But I think just in principle, as a representatives of the industry, I would argue one very, very important thing, which is we shouldn't use decentralization as a marketing tool or as a marketing in a way topic. So even regulators or the industry, if we're not really decentralized, if you're not really a DAO, maybe it's best not to use this wording. If there is going to be potentially a framework for DAOs in the future, I don't know if it is or not, but I think we would rather need to call it in a different way if it will really not represent something that the industry think the DAOs are. So the worst case would be to, as lawyers, have something and have like, I would say, capture the term that the industry has been working on for such a long time, or at least thinking about, in a legal term that would not at all represent what the industry think DAOs are. So yeah, I'll leave it here. Thank you for the patience.
Mats, please.
Thank you. Can you hear me better now? Is that sound okay? Yeah. Thanks, Marina. I think you brought up really, really interesting and good topics to discuss, and I completely agree with your last point on DAOs. It's too many projects calling themselves a DAO, but I think kind of the overarching question really on what you brought up is, you know, what's the right balance between innovation on one side and kind of gatekeeping, protecting the investor on the other side. I think, at least from a Nordic standpoint, Swedish, Norwegian, Denmark, my impression is that the NCAs, to a too large extent, think of themselves as a gatekeeper, and they want to include as many projects as possible in order to kind of protect the investor. But in many cases, they then really they really took down right on innovation, because then you have lots of different projects who cannot be a financial institution. They're not rigged for it, right? So they basically kill projects. They kill open source innovative projects, which then again in the end reduces, let's say, competition from the European side against other markets, just like the US market perhaps will evolve, and other markets in Asia as well. And so I think NCAs in Europe, to a much larger extent, at least on the Nordic from a Nordic side, should think themselves as also keeping innovation as one of kind of their goals. Obviously, they should be gatekeeping, but also think of innovation, because if you have a too wide scope of who should be a CASP, then you basically are killing many really good open source projects, and you're basically saying to software developers that you need to be a financial institution and have a much larger rig than what is possible for many of these projects.
Yeah.
Yes, thank you. And I also wanted to raise awareness to the chat that is happening simultaneously, because I know that the listeners and viewers afterwards will not be able to see it. But we're also talking about significant issues related to the vocabulary we are using, and basically who is also responsible for that. Because when it comes to MiCA, and going back to MiCA, because that's the topic that we are discussing here, broadly speaking, MiCA regulates activities. So basically, it doesn't really, the regulation itself does not put that much attention on what you're calling yourself and how you're calling your activity. So this is going to be even stronger when it comes to NCAs evaluating. And Paul, I will also go back to the example that you're giving related to GDPR. When it comes to regulations like that, and NCAs, and even broadly speaking, European Court of Justice and Data Protection Board, those authorities that are more on EU level, it's very much a box-ticking exercise, because, for example, GDPR, we need to have a data controller, data processor, not necessarily a data processor, but data controller every time when there is any data processing taking place. So in this case, there wouldn't be that many questions about, okay, is it decentralized, is it not decentralized? If you have the activity, then we will have to find an entity. And I can easily imagine this being the case, widely speaking, with MiCA, especially on a member state level, and especially with the vocabulary that even among us isn't quite aligned. So that's also something to keep in mind, whether or not we can also influence the vocabulary, and then at least start from there.
Okay, thank you very much. I have you made me think of a question for Marina. I don't know if you can answer, if you have an answer. But there is, because I know I made a research some time ago that the legal status of a recital in the European Union pieces of law. Basically, there is a clear case law from the European Court of Justice, but also there is a document from the European Parliament, and the recitals technically have no legal value, but are principle that has to be used as interpretation of the articles of a piece of law. So I was asking myself while we were discussing here, if Marina, if there is a reason, or if there is a reason why it was put as a recital and not as an article of MiCA.
Yeah, that's an amazing question. Definitely, we were pushing it for it to be an article, but it didn't happen. It's just, I would say, the negotiation process and all the advocating groups that are involved in the process. I remember, I think it was again May 2022 or something. We have written a lot of feedback to MiCA, and in the next MiCA in a way draft, there was a lot of things that were just accepted, and that felt too good to be true. And then within the next month, the next draft, because there were new drafts every week, a lot of it would just be canceled. So we were just thinking maybe they have talked to I don't know, some kind of a banking, advocacy groups or something similar that made them rethink certain things. So it's really just a process. It's really like a political process we have gone through and we passed. And right now we are here discussing as lawyers, what does it mean and in which way can we help, any type of like clients to understand better those things, and can we have like an enforcement, can there be an enforcement or can there be a non-action letter? So this is really left to us. And what Matt said before, thinking about also being proactive in terms of discussing with NCAs, but also later on when we will actually have enforcement actions, for example, will there be something done around this? And I know that there's, of course, a lot of different articles, for example, that we're discussing, like academic articles that are definitely useful for the industry, but they are coming from both sides. So it's also on us to understand and to look into what ideas are good for this case.
I don't know if there are other questions, comments. Everyone?
I might have some for the audience
Yeah,
as
please.
well. Like, I think we're
Please.
discussing DAOs a lot, I think specifically when it comes to DeFi, and financial regulation, but there's a lot of thoughts that we also have on, like you said before, anti-money laundering, terrorist financing. There's a whole discussion right now how to use software that could help us understand if there's like any type of, sanctions activities or sanctions parties being involved. What about that part? I think in theory that part is even harder to negotiate somehow when we think about decentralization. We should go back to the FATF definition of what a virtual asset service provider is. I think it's always kind of the Bible to understanding what is a VASP versus what could be a DAO. And there specifically also I wanted to point to a specific part, which is the fees. The part there is talking about fees and the business kind of activities within those potential DAOs again. So if there is a fee on a front end, if there is, kind of an idea that there could be a business relationship, wouldn't that be somehow easier for an NCA to argue that this is a CASP versus, again, a decentralized project? And how to argue if those parts are also decomposed, like, for example, again, one entity front ends, the other one software development, etc. So maybe leaving it to the audience.
Anyone?
If I may, hi, this is
Please, Maria, please.
From Avara Labs. I think something that's not often discussed enough is that I see kind of front-end fees as kind of a positive development. I think one of the things that is not emphasized enough is in this conversation is how important front ends are, and we should have more, better, safer front ends for users to choose from and engage, possibly on a kind of like a multi-protocol basis. And I think in the space we have this issue that it's very hard to monetize these products. And that often leads to a lot of really good projects ending up creating tokens maybe slightly too early. And I think this is partially driven by the fact that there are these risks in taking transaction fees through front ends and other ways. And I think it could be more optimal as a long term if you were able to actually monetize, and then you could hire customer support, you could kind of make sure that the front end is as good as possible and make it as a sustainable independent business where you could differentiate the people building those DEXs and running those DEXs to focus on the kind of smart contract components as opposed to running the front end. I think it's a very different type of activity than the kind of the underlying smart contract and network development. And I think in the front end conversation, and whether these should be CASPs or VASPs or whatnot, there's often a big exaggeration on what's actually in the hands of the front end. And I think front ends actually have a lot less control over the transactions that there are. Somebody called it routing. I'm not sure if I would say it's routing users to these DEXs, but nevertheless, there's a lot that happens on these networks, and especially since they're kind of increasingly bridging from one network to another, and all of that is permissionless and completely outside of the control of the front end, and we shouldn't really kind of forget that. So I think there's a, just a technological reason why front ends necessarily can't provide the same level of support that a CASPs could if you are built in as a centralized business. And I think there needs to be some kind of a nice space for these front ends to operate. Those were my general 2 points. Thank you.
Thank you, Maria. So Alvin and later Marina. So Alvin, please.
Thank you, Paolo, and thank you, Maria, for that. I feel, or I firmly believe that front ends are the legal battleground during the coming year, or maybe even years. I think regulators have a tendency to regulate. That's their mandate, and they try to find what they can regulate, and front ends are a very viable target in that regard. With that said, I think that the natural development of front ends is that it will almost become like a service provider, a tech service provider, where tech service or tech platforms will start providing front ends to DeFi platforms. I think that it will be a natural progression of regulators coming after front ends. So I think front ends will more and more be outsourced to tech providers due to this regulatory uncertainty, and hopefully, or for to also be able to truly make the claim that you're fully decentralized, or at least that you're not providing the end front for where users typically interact with your DEX. I think that I may be completely wrong, but that is sort of what I'm seeing where our industry is heading, maybe in the 1 or 2 years, unless we get clear guidance from ESMA or EBA, or even one of the bigger NCAs, that front ends can be a front end solution belonging to the original team can still be a part of a fully decentralized DEX, for example.
Thank you, Marina.
So I love these discussions, and I'm going to propose some proactive things here. Actually, one first is, Maria, thank you for this topic. It's super important, but in general, everyone, like, how do you feel on having some sort of disclosure requirements for front ends, if that would be useful for the consumers to have, front ends that would be safer? For example, those are, this is what's happening on this front end. This is the person that is like handling the front end. This is how we are making sure that the front end is really doing what the front end does say that it will do. It's really connecting to the right, like backing it again, smart contracts, etc. Like something that would be much more like light touch, rather than having the whole compliance that is the one that is super heavy that the CASPs need to do. And then the second one is really, if we do something like this, and if you do something like Elvin suggested, or there's even ideas that, let's say, CASPs could integrate DeFi projects, for example. We don't have only MiCA, but there's DORA in Europe as well. And this is what we have discussed. It's super, super important that the CASPs are compliant with DORA. The latest ESMA paper, ESMA and EBA paper on DeFi, staking, etc., that was feeding into the European Commission's paper that will come up very, very soon, is really, okay, there's only 4% of DeFi integrated in TradFi. So why is this so? Of course, there's like such heavy, compliance that TradFi needs to do in order to integrate that. So how can we find like a middle ground where this could happen? We know like mostly all the like a lot of DeFi projects, I know that their idea is really the integration. Or do we need to completely build these two things in a separate way? So we have one that could be integrated in the future and will need to be compliant with all those rules. And then we have the other one that might be more for retail and can be done in a decentralized way. I feel that America, in this sense, is much more like open, and I think they have like more flexibility in this type of integrations, and they will definitely happen in the next years. But I think in Europe, again, like if we go into details of DORA, it could be pretty complicated in the sense.
Thank you. So Alvin, please.
Yeah, thank you for that. And Marina, I fully agree with you in spirit. I mean, I think it would make sense, for example, to have light disclosures for front ends, or if front ends as a service becomes a real thing, that they can also be somewhat regulated. The thing is, what I'm worried about here is that as soon as that door is open, it doesn't stop, or at least this is speculation, of course, but knowing how the EU operates, I don't think it stops with disclosures or industry standards that are acceptable and will let the crypto industry thrive. On the contrary, I think we will not only get disclosures, but then all of a sudden I think we will stack the typical centralized requirements. We will add, KYC, KYB on top of the front ends, and we will just over-regulate and make this unfeasible. Now, I sound very cynical when I say this, but that is my concern, I would say, that then they feel like, okay, now we can impose what we want to impose, and we found the right party to do it on.
Yeah, I'm
Marina,
actually not arguing for that. That was a question for, thoughts and debates, because I think in this sense, we would need to go into, meetings one-on-one with NCAs and different member states, different projects. And I think it will leave us with that. And then we'll see how far we will come. And then we'll do forum shopping, and we'll know which one is, more knowledgeable and knows more, etc. So I think that they will still, we will still need some time to understand where we are. And I think the best knowledge will be really in the project that will do this research and maybe talk to the lawyers, or the lawyers themselves, of course. And then more, I would say, kind of discussions, the more discussion in this direction, the better it is, for sure.
Okay, thank you. Other points, comments?
I have
thought
another.
that just very short on the same topic, because you have for prospectus requirements, right? You have kind of a light touch prospectus for growth companies, but if you look at it, it's not really that light touch. So just to Elvin's points, I think it's easier than to go in direction where you kind of over-regulate a bit. Then it needs to be a really light touch if you are supposed to kind of have that middle ground regulation, not like the prospectus requirements for growth companies. Just short comment.
Yeah, thank you. Marina?
Yeah, the question is, can Europe do light touch? That's the other thing,
No.
or we should just do it in a
No.
in a kind of non-formal way. It's just like, how it is, and we research this thing. That's definitely a question. The other one is if we need something from DAOs, let's say some type of information, there is someone, researching specific things, maybe related to anti-money laundering, etc. Can we teach the authorities to reach out to DAOs themselves? Through the way how DAOs function. They go into Discord, and I might be copying someone that I heard this saying. They go to Discord and, ask there, we are doing this thing. We need some information. Can we do that? Can we be a little bit more, adjusted to how DAOs actually function, instead of needing an email or something that they're usually used to? Would it work at all?
Bit difficult. Maria, please.
Yeah, my experience through particularly aave.com is that's kind of a way where people find kind of and regulatory authorities and users and everyone finds their way to send us an email even when it's not something that, for example, Aave is in Aave Labs' kind of scope or control. And they do understand, from what I've seen, that when you explain to them that, this is actually not how it works, we are just software developer in the ecosystem, and you might be able to guide them guide them forward and explain how it works. And I think it's been fairly successful to be open and responsive. Haven't kind of seen particular issues on that end. I think the communities need to remain open, and it's good if there are these, but I do understand that there are projects who kind of are more hesitant or nervous to provide a way for various community members to connect. But I think having a lot of information on your website and on your front ends as it is, how things work, is generally the best practice. And I think websites already kind of, as far as I see on front ends, very well do this. So thinking about kind of additional disclosure requirements, like my feeling is that most front ends already have very good and visible and transparent information about how it works in there. So I'm not sure what would a special disclosure regime add. But I do say that, and I think this is in general probably across crypto ecosystems and CASPs and all that, that user support is a landscape where I think there are still places that like could be more solutions to support users, because you are engaging in an environment where there are multiple networks that might be facing issues. You might be interacting with multiple smart contracts at the same time. You might be using a DEX and another type of protocol at the same time. And then there is this space where when whatever you're doing might not fall even just for one DAO. It might actually touch multiple ecosystems, and there needs to be a coordination. That I see that there is a big space that even if the EU would manage to propose some kind of framework for DAOs, it would still not fall under any one particular project's purview. And I always hope that there are enough, and I've seen there are enough people in the ecosystem who are open to support, regardless of where the issue is, as long as they're able to see it through the transparency of the ecosystem. I think there are a lot of good teams in the space helping.
Thank you. Marina?
Yeah, I hope I'm not taking too much of your time. We'll have enough for all of you to comment, but I really think that when we are in this space for such a long time, we see the best practices and we can identify the best practices, and we do see, as Maria mentioned, so much information on the website. We know which, for example, companies are really thoroughly following best auditing standards, etc. But like for the newbies that are just coming in and they don't see these differences, I do understand that it's harder. So there would need to be some sort of a information, easily accessible information for them to know, okay, this is one of the best, safest protocols that I should use. If I am engaging in a completely new one, I need to understand that this is, much more riskier than the ones that, in a way, people that know and engage in the space are using.
Mats, please.
Yeah, I've been wondering whether we need some sort of a new corporate formation somehow, because right now you have the DAOs. They kind of operate like a partnership or and certainly not a limited liability company, but they want to remain with limited liability, right? But in reality, they kind of operate like a partnership or a cooperative, really, like a combination of a cooperative and partnership. And I think many token holders think they have limited liability, but in the end, they might actually be liable both tax-wise and legally, right, for the whatever activities the business actually conducts. And so I've been thinking, should we kind of further evolve the corporate structure, because it's 150 years old, right? Should we evolve from a limited liability company into something new, which kind of the decentralized people, people has, form themselves into some sort of a combination of a cooperative and partnership, but with limited, well, they wanting to have the limited liability. Should we, as kind of from the more kind of government side, society side, actually form and allow this structure to become a formal corporation somehow? I've been kind of wondering that, at least from my end. I don't know if there's any thoughts on that one.
Thank you.
Yeah, just
please.
a short answer. In theory, absolutely. In practice, it means changing the laws of 30 different countries. when it comes to corporate structures, or having something on an EU level that all these countries would agree on?
I would like to add something myself. I think that decentralization, there's a lot of tension with the traditional legal categories. I mean, it's just a problem that many traditional legal categories that have been created through the centuries don't make sense typically in crypto. We try to really to push as lawyers and even the regulators, but in many cases don't make sense. So I agree with Marina that will imply to change the law of 30 member states. But I also agree a lot with Matt that, and in my opinion, really the problem is that in the crypto space, a lot of the law should evolve into just a kind of a body of law specific to the space, where many legal categories just make sense for crypto and don't make sense outside crypto. But that's my opinion. So I don't know if there are other comments, questions,
or just or just standards or best practices as an industry, like, you know, thinking about that, and then whoever is interested following those might be interesting. But I think that I think we're going slowly to an end of this discussion, but I really wanted to ask everyone's opinion on, we have MiCA, we have the Recital 22, but right now there's been proposals for, in a way, certification for smart contracts. And this is coming from another part, and it's on the technical side, of course, but it, I think, could influence, in theory, even this decentralization part, or even this part of like, okay, DAOs are composed from smart contracts, more likely, more or less. If we will need the certification, there will need to be a process. There will need, again, an entity that will go through that. They will need to be granted. If it will be mandatory, how could that influence decentralization as well?
I can answer just from my point of view, and I would recall from that experience that I was just describing before. That will impact a lot, because of course you need to pay for certification. Someone needs to put a signature at the bottom of a contract, which is not really for a real pure decentralized project, as I was put in my own case. It's complicated, because who can sign really a contract for a decentralized project if it's really decentralized? So that will create a big of tensions, Marina, I think, for real decentralized project. And there is Tommaso here. We made we both participated in an event which I organized in Rome about Data Act, and in the Data Act there is, and Tommaso was speaking in that case about this article of the Data Act, that article of the Data Act about the requirement that the smart contract in relation to data sharing agreement. So it's very narrow somehow, but need to be certified, need to have a number of requirements for cybersecurity related issues. And there was a big debate in the space, and Marina Tommaso was actively being part of that debate, not myself, about whether that could being potentially impactful for the entire crypto space. But in my opinion, the final version of the Data Act is not so dangerous, because it's just only related to data sharing agreement. But still, it poses a precedent about that. I think that from one point of view, it makes sense. It's reasonable that smart contract should be certified, or maybe not certified, but should be strong, because of course there are a lot of scams in crypto. That's negative for sure. But on the other hand, certification as a process, it's really incompatible with a decentralized project or organization or entity. I don't know. That's my opinion. Someone else wants?
Yeah,
Tommaso?
maybe yeah, I'll just jump in on here. Thanks, Paolo, and thanks again, everyone for organizing a nice debate. I just got where I needed to go, so at least I can speak now. No, I just wanted to, I think, mention here that yes, the data Act was basically the first attempt that we saw, right, at talking about the certification for smart contracts. As you said, this was in the end pretty limited in scope, so I don't think the overall impact on the wider use of smart contracts in Europe, as materialized there as we were actually worried about, right? Back then when we were having these discussions. I think now, though, when we're talking about certification of smart contracts, the real dangers, the real issues are coming more from France again. I think you may have seen the latest paper by the ACPR and AMF that published the results of their working group on smart contracts certification. And that's also now again put up for public consultation till the 10th of March. So obviously as Blockchain for Europe, and I'm sure as UCI and all the other actors that are very active in the space will be responding to that consultation. And again, basically reiterating some of the points that we just made, that you guys just made in this discussion, right? So how feasible it is to envision a mandatory, even because we talk about a mandatory certification schemes for smart contracts. And in that sense, there's obviously in this regard, the scope is much wider. It's not just the one limited to industrial application of smart contracts where there are, private companies deciding to use smart contracts for data sharing agreements, right? Which is the scope of the Data Act, which again is something that in that specific context can work, because then there is a company, there is an entity that is taking the responsibility of deploying a certain smart contracts on their closed network for industrial data sharing, and then they can decide in that sense to make sure that it's fair to say that they should ensure that their smart contracts are respecting these requirements, right? But then again, when we look at the paper by the ACPR and AMF, there's really some dangerous conclusions made there. So I would invite you all, if you haven't read it yet, to take a look at it, because they're talking again about the role of interfaces, as we were discussing before, and again, this idea of a mandatory certification scheme for developers and deployers, rather of smart contracts, could indeed be very problematic. So, we're going to be putting together a response. I'm sure there will be more opportunities to discuss about that and potentially do things together as we've done in the past very successfully. I guess generally it's just a reminder for the industry that even if there is no, regulatory push, as it was also said, to now bring in DeFi into the regulatory perimeter of MiCA, or generally to have a new specific legislation on DeFi, which is likely not going to happen anytime soon. But then, there are these other attempts and discussions and considerations being made at national level that will, in any case, influence, of course, the European level discussions, right? So, yeah, just I guess a reminder for us all to be quite, to be closely paying attention to these developments and to national authorities that also put out there these sometimes, complicated or controversial statements. We also mentioned the Danish authority, which is also another one, which would, of course, have a potentially pretty big influence over the way that decentralization is perceived by the other NCAs around the EU, right? So, anyway, lots of things to think about, and I think a lot to do still. I guess that's the general reminder for everyone here in this call.
Thank you, Tommaso. Other
Yeah,
ideas?
just saying that agree with Tommaso, and as important, the discussions around decentralization, where in 2021, now we have the new one on DeFi certification or smart contract certification, and it might not become a law at all, but if it will become a law, in 4 years, everyone will start asking us what it is about and how can we comply and why it is so terrible. So if anyone wants to be involved with that, reach out to us, because as Tommaso said, we are responding to the papers. We are engaging with regulators that are having the ideas to basically impose those certifications. If you don't want in 4 years to just learn about that and then try to comply, but it will be hard, or there will be some limitations, as it is happening right now with MiCA and Dora and everything else. So that's why we need to keep an eye open on what's happening. And same with the Data Act. I remember when we started, kind of seeing alarms, red flags in the Data Act, we had to really talk to some people in Brussels because they haven't seen how problematic this part is because it was so technical. Most of us and the others were really focusing more on the business side of crypto as a service providers and MiCA. And when it comes to this like very small technical issues, they were not really seeing how problematic this is. And we had to put a lot of effort into making everyone understand this part. So I think that really the highest risk, what can happen in Europe is that there is like some part that changes in a law that requires a technical part or a technical design to be included in blockchain, which is not compatible with open blockchains. And then the limitation could come from there.
Yeah, I personally agree with that totally. And anyone else? Some question? Remarks? Final conclusion? No. Okay, so I think we could probably close this debate. So I will really thank everyone here, panelists, not panelists, just guests, for having participated to this debate. And so this is a LexDAO panel. So I really would like to thank you everyone again. And this will be recorded has been recorded, and so will be published on the LexDAO YouTube channel. So thank you everyone. Bye. Bye.
Thanks everyone. Thank you, LexDAO.
Thank you so much. Bye-bye.
Bye.
Thank you, Paolo.
Bye.
Thanks. Bye-bye.